Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you today. First, Richard Allen is not going to get much relief on that whole alternate suspect issue. Bryan Kohberger has a hearing today on the change of venue. Chad Daybell's new attorneys get more time. Robert Tellis is found guilty. Only surprise was that they were out for 2 days. The Deadpool killer is sentenced to death. Kouri Richin, she gets a case bound over to the district court, and a trial date is set. Why you need to keep hands off of other people's things, and then our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications of when we go live or put up a new program. So please remember to do that, because we get a notice from a lot of people saying that they somehow subscribe, they've hit the bell, and they still aren't getting notifications. So I think you need to keep doing it until YouTube finally knows that that's what you want to do. Receive notice.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado's CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
Anyway, all right, let's go ahead and get ready for the docket for today. It is August 29th, 2024. Can you believe it is August 29th? The year is almost over, ladies and gentlemen. All right, first on the docket, Richard Allen. That's right, the Delphi murder suspect, Mr. Allen. His defense is missing the proof needed to present evidence of Odinism, ritual human sacrifices, and third-party suspects in front of the jury, according to the prosecutors and their briefs that were filed. The briefs note that, quote, in order to present evidence in relation to a third party at trial, the defense must show a direct material connection between the third party and the crime. The connection must be based on more than hearsay, speculation, rumors, and conjecture, or even just theory. It must be based upon reliable evidence that draws a material connection between the party and the crime. I've mentioned in the past that this was obviously the issue when you just try to say that a third party committed a crime and it wasn't the defendant. You have to have some reliable proof. You have to have something that shows they're actually the ones that did the crime. So for those who aren't familiar with the case, Richard Allen faces 2 charges of murder and 2 charges of murder in the commission of kidnapping. Now, his attorneys have alleged that several men who worship Odin, a pre-Christian Norse religion, are the ones that sacrificed Libby German and Abby Williams in a ritual killing on the afternoon of February 13th of 2017 on the north banks of the Deer Creek River east of the Monon High Bridge in East Delphi. Now, during a hearing that took place on August 1st, Allen's defense team asked Special Judge Francis C. Gull to allow them to present evidence to support their case. Now, the argument is there were these Odinists, not Allen, that killed the Delphi teens, and it is an argument that they have outlined in the filing with their court. Allen's defense presented a 136-page memorandum back in September and a motion that details the defense theory that Libby and Abby were killed in this Odinistic sacrifice. But by contrast, at the August 1st hearing, the prosecutors wrote in their brief that the defense has only offered up speculation supported by conjecture and buttressed by what-ifs, without evidence, material or otherwise, that these were ritualistic murders. The defense speculation that various social media posts could be connected to the crime scene. Well, Allen's defense argues that if Judge Gull grants the prosecution's motion, it restricts Allen's Sixth Amendment right to present evidence, including that other people were in fact the ones that killed the Delphi teens. Now, Gull has not ruled on that particular issue yet, and trial is scheduled to start in October. Now, the defense did note that they have good reason to believe that Richard Allen is not the only person involved in this case, that there may be other actors. Now, the prosecutors said during their hearing that less than a month after Allen's arrest, it is in the public's best interest that the investigation find anyone else involved in the case. So this is it's an interesting issue, but here's the thing why the defense has to, even if the judge says, no, I'm not going to allow you to bring in evidence of a specific person, the defense can still work around it. Trust me, they can work around it. And remember, the defense will always have a right to say, the defendant didn't do it, right? The prosecution always has to prove that it was the defendant, not someone who looked like him, not someone using his identity, but it was in fact him. Now, obviously, Mr. Allen has put himself, by his own statements, near that bridge, that scene that particular day, and there's fairly numerous confessions that he has made as well. So it kind of is working against him in that regard. And like I said, you can come up with all kinds of theories that you want to come up with, that a meteor struck and that's what, you can come up with anything you want. But you have to be able to prove it. And that's why I think sometimes people get frustrated with me in these cases that we discuss. It doesn't matter what you think. Only matters what real legal incompetent evidence you can bring to court that's going to be admissible under the rules of evidence. Been dealing with this for years and years and years, but hopefully our show is to bring it to you straight and correct, and to show that you can speculate all you want, but it only matters what you can prove. Next, the Bryan Kohberger hearing. That's right, there's a hearing today to determine whether there is sufficient evidence to move the case of Bryan Kohberger from Latah County down to Boise, Idaho. Now, the defense has the burden of showing that there is going to be prejudice to the defendant in this particular case. And then the prosecution really has to rebut this. Now, the hearing's just started. In fact, they're on the break right now as we're doing this show. But you have to remember, the only evidence that's really going to be presented is from the defendant. We've already heard a lot of it as it relates to the evidence, as it relates to the survey that took place and the results of that. We've talked about those in the previous motions, that basically some 70% of everybody in Latah County believes that Bryan Kohberger is in fact guilty. And there's only 40,000 people in that city, but if you go to Boise, there's 400,000 people. It's a greater pool in which to choose from. If the prosecution doesn't come up with a better argument other than let's wait and see during voir dire, I think the judge, that's his name, Judge, will have to grant the motion for a change of venue. It will be inconvenient, it will be expensive, but it will get done. It makes no sense to take the wait and see position, in my humble opinion, and then only to find out that you cannot seat a jury. I understand people will be disappointed. The family will be disappointed. The taxpayers will be disappointed. The county commissioners will be disappointed. But it's a process, and you got to go through the process, ladies and gentlemen, to get the result. And you got to make sure it's fair so that it doesn't come back on appeal and you wind up doing it all again. So just move the darn case. All right. Next on the docket, Chad Daybell gets more time. That's right, Judge Boyce found that there's extraordinary circumstances in the case of Chad Daybell and granted his appellate attorney's request for more time to file their post-conviction relief motion. So yesterday, Judge Boyce heard argument from the appellate attorneys for Chad Daybell. He's got 3 of them now, that there isn't enough time in which to prepare a proper pleading. Now, the court did not televise this on the court's YouTube channel. Now, we do know that Daybell appeared via Zoom from the Idaho Maximum Security Institution in Boise, and Daybell's attorneys cited reasons why more time is needed to effectively represent him. They said, quote, "We are clearly committed to Mr. Daybell and giving him the very best representation that we can. We also know the restraints under which we operate, and we are going to do our best to meet both of them." Now, in Idaho, like many states, when there's a death penalty case, a motion for post-conviction relief must be filed within 42 days of someone receiving their sentence. Now, obviously, 42 days for new attorneys is not a long time, and it's only fair that they get that additional time. But a lot of states have said, hey, instead of going through the appellate process and then the post-conviction matters, and then appealing the post-conviction matters, let's combine them. Job expands to the amount of time given, but 42 days is not that long, considering everything that the appellate attorneys and post-conviction attorneys would have to review, get up to speed on, be able to draft any sort of post-conviction hearing request. It's simply not doable. So anyway, also under the law, any hearings and rulings on that post-conviction relief must be done within 90 days, meaning that Chad Daybell's case would have to be wrapped up by October 15th. Obviously, that is not going to happen. Apparently, they have some 16,800 pages of trial transcripts to go through, 12.7 gigabytes, which is about 18,000 CDs of information, to give a little perspective. And his office also handles the other 7 death penalty cases that they are working on in the state of Idaho. So needless to say, they got to work faster. And apparently, the post-conviction attorneys came across some information just a few days from the trial that dramatically changed their framing of the issues that they are going to present in regards to mitigation. And so as they go further into the case, they expect different insights to emerge, is what they told the judge. And more than any case in his last 26 years, the attorney noted this case presents the facts that there are extraordinary circumstances. Mr. Daybell has a statutory right to counsel and obviously to post-conviction relief. He's also entitled to effective assistance counsel. And they state that without additional time, they will not be effective. Those are the magic words for a continuance, ladies and gentlemen. So obviously the judge was going to grant it. And the prosecuting attorney didn't oppose the motion because she realizes that more time is in fact necessary. And the Idaho Supreme Court must approve Judge Boyce's ruling for the post-conviction relief proceedings to be continued. And assuming that happens, which I think we can say that it will, Judge Boyce will have to then set up a scheduled conference to keep the case moving forward. But the judge said, quote, "This case shows extraordinary circumstances that would make it impossible for the post-conviction petition to be fully completed by October 15th, the judge ruled." So, as you may recall, Chad Daybell was sentenced to death in June following his 8-week trial where he was found guilty of murdering his wife, Joshua J.J. Vallow, and Tylee Ryan, who were the children of his wife, Lori Vallow, who was also convicted of the same crimes, but she is serving a life sentence. So although it won't be done by October 15th, I think it will be done within the next 6 months. We'll have to wait and see. Next, a jury found the former Las Vegas area Democrat politician charged with murder in the death of an investigative journalist guilty. Robert Tellis was sentenced to life in prison with the possibility of parole after serving some 20 years. Now, jurors began deliberating Monday to determine if they could agree on the prosecutor's allegation that Tellis stabbed the journalist Jeff German to death back in September of 2022 after Mr. German wrote some critical articles of the politician and his workplace conduct, including allegations of an inappropriate romantic relationship with a female coworker. Jurors deliberated for about 4 hours Monday before breaking for the evening, and then the jury panel of 7 women and 5 men deliberated for about 6 hours on Tuesday following the 2-week trial. The attorneys had given their closing arguments on Monday morning. On Monday, the jurors sent a judge a note seeking that they needed some more notepaper and a court technician to help them figure out how to zoom in on a laptop video that they had in their case. This case just shows you jurors take their jobs very seriously. The verdict probably could have taken 15 minutes, but it shows that they took the time to go through it, to review the evidence because they knew it was, in fact, a serious case. Well, the process worked, and the justice prevailed. Next on the docket, the Deadpool Killer. That's right. After being convicted of double murder, Wade Wilson, who's been dubbed the Deadpool Killer, appeared in court and was sentenced to death. Now he showed off some of his interesting tattoos that some people say associate him with white supremacists. And a lot of those he did not have some 5 years ago. Now, he did smirk when he was sentenced to death for the woman's death that he was found guilty of. And needless to say, not a real nice guy. Anyway, the judge told him he will die for his crimes. A jury voted in favor of the death penalty, 9-3 for the victim Melton's case and 10-2 in the Ruiz murder. Under Florida law, only 8 of the 12 jurors need to recommend a death penalty for it to be considered by a judge. Now, the jury found that the crimes involved aggravating factors, including that the crimes were especially heinous, atrocious, and cruel, committed by a person convicted of another capital felony involving the use of violence to that person, and committed by a person previously convicted of another capital felony and under the sentence and imprisonment and placed on probation or parole at the time of the offense. Next, Kouri Richin, the Utah grief book author accused of killing her husband with fentanyl-laced drink, the Moscow Mule. Well, she's going to have a trial date. That's right. Her case was bound over after the preliminary hearing, and a trial was set for April. So after the 2-day preliminary hearing, there was sufficient evidence, nobody's surprised by that, for the case to go to the district court and bound over for trial. Trial is set for April 28th, and it is expected to last 4 weeks. Now, if you're not familiar with this, Ms. Richin was arrested back in May of 2023, accused of poisoning her husband, Eric Richin, with fentanyl-laced Moscow mules. And later she self-published a children's book, Are You Still With Me?, about dealing with the death of a father. In addition to aggravated murder, she's been charged with attempted murder, assault, and drug-related offenses relating to her husband's death. And Richins also faces charges of mortgage fraud, forgery, and insurance fraud for allegedly forging loan applications and making fraudulent insurance claims after her husband's death. And we also found out during the preliminary hearing, apparently she was being comforted in the time leading up to her husband's death and possibly thereafter by her boyfriend. Sex, drugs, and alcohol, ladies and gentlemen. That's what keeps all criminal defense attorneys employed. That is the root of all evil for society. And I say that somewhat jokingly, but every case, when you ultimately look at it, sex, drugs, and alcohol, ladies and gentlemen. Next, a woman experiences some consequences of her actions. Take a look at this young lady. She apparently didn't like what somebody was saying. It looks like it was on a campus of some type. And she took the man's sign that she didn't think that she liked what he was saying about it. Well, guess what? That's called theft, larceny. Keep your hands to yourself. Get a thicker skin, young lady. You don't get to take other people's property just because you don't like what they say. Unbelievable. Think it shows the state of the nanny state, the snowflake world, that I don't like what you're saying. I'm going to take your thing. They think it's cute. It's funny. Well, guess what? Look at that video. She got arrested for theft. Need more consequences to actions, ladies and gentlemen. You get more of what you tolerate. Now, take a look at this, our dumb criminal of the day. I'll be honest with you, first time I saw this, I thought this can't be real, but nothing shocks me anymore. So I don't know if it's real or not, but either way, it's still kind of funny. But this guy apparently broke into the person's house the night before or some time back, and the burglar apparently realized that he couldn't find his keys. So he went back to the house asking the person that he apparently burglared their house, are his keys in there? Take a look.
Yes.
Hey, how you doing? Hey, I know you probably don't know me, but I was the one that broke in your house yesterday.
You did what?
I broke in your house. Anyway, that's neither here or there. Have you seen a set of keys laying around anywhere? Because this was the last place I know I had them.
Is you serious? Did you really come to my house looking for your keys?
Yeah, why would I go to anybody else's house looking for their keys if I know I have my keys at your house? Have you made it here yet? Because I can glance around real quick and see if I see them.
You know what? I'm about to call the goddamn police on you.
You ain't got to do all that.
You broke into my house. Why didn't you break into your own damn house?
How ignorant would it be from... Man, really, think logic. How ignorant would it be for me to break in my own house?
Man, if you don't get your ass off my porch.
Man, your porch.
All right, ladies and gentlemen. Like I said, I don't know if it's real, but it's kind of funny. Anyway, that's all we have for today. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.